or email us at clark@japarliament.gov.jm. Visit the Parliament's website at www.japarliament.gov.jm for details.
In our Joint Select Committee meeting, we ask you, Lord, to open our hearts and minds to the task ahead of us. Help us to do it to your will, to your glory, in the interest of our people. In Jesus' name I pray. Amen.
Thank you very much, Senator Campbell. Any apologies? No apologies.
Is it?
Dennis.
Oh, it works on red and stops on green.
No. Green is an invitation to proceed. And red, you. Thank you.
Senator Lambert Brown.
So there are two, Dennis Daly and Senator Lambert Brown. Members, thanks for being here. Thanks to the technical team for being here. I don't suspect we're going to have a long session. The main focus of today's meeting is to confirm 4 minutes which are before us, and also to look at the protocol, how we decide on the recommendation to Parliament. There are 3 very short bills. We have had some very interesting submissions, and I think immediately after we deal with the confirmation, I would like us to have a discussion how we proceed to making that final decision. Okay? So without further ado, therefore, I'm going to ask members if they had had the opportunity to read the minutes. I read a few corrections I've passed on to the secretary already. So if you see any corrections that you would like to identify to the secretary, fill in which then as soon as you're ready, we can do. As you can see, the minutes are very extensive. It's almost verbatim. If you're having corrections, you could point them out. 4. And when you're ready, we can. I don't know if members, I must admit, the minutes will take a little time to read because they are very extensive. Would you like us to put it off till the next meeting and we just confirm them?
I'm still trying to get used to this. Normally when you press, you can speak.
Right?
Chairman, I have no difficulty in, again, suspending the minutes and for us to try and determine how we proceed going forward operationally. So I have no difficulty in doing that.
I think it would be more useful to use our time to have the discussion.
Yes, to have the discussion.
And agree?
Yes, Chairman, and could I just suggest too that perhaps we can just have a special virtual sitting to deal with the minutes?
Well, to be fair, rather than that,
we wouldn't necessarily...
I don't anticipate we have at maximum 2 more meetings, maybe even 1, if we can make a decision.
To go through the matrix, Chairman? I don't think you're going to be able to do that in 2-minute meetings, with respect.
You see, Chairman, we're talking about 3 different legislations. And we have a matrix that will first have to determine if they are the different recommendations, if they are compatible, so we can form them into one. But we really have to align each respective proposed amendment to be associated with a particular legislation. And then we can start conforming.
Right.
So it may, in my mind, and the little experience that I have in going through matrices, is it may take more than 1 meeting.
No, well, fair enough. And I won't be rushing. The main thing is we need to look at the matrix. Okay, so we can decide which areas we should try to adopt or which set of proposals we think are influential, and then we move from there. But in all sincerity, the main thing is that when you read a lot of, especially on the Child Care and Protection Act, the submissions are fairly similar. And those were where most of the submissions came. You see, those are where most of the submissions came. So that, apart from in the other two bills, the main thing was basically indicating the main concern was that a lot of people didn't agree with the mandatory minimum, or they think that it should have been higher or low, the submissions.
Yes, you're quite right. A lot of the discussion surrounded the child care and protection and the mandatory minimum. In fact, I would even want to believe that is where a lot of the deliberations were grounded.
Absolutely.
So it could form the easiest aspect of associating compatibility in terms of the matrix.
All right, well, let's begin the discussion then. I mean, if you don't mind using chairman's privilege, let's deal peremptorily first, not peremptorily, first with the child care and protection and the submissions. And also to note, we're not making any decisions today, okay? We're making some suggestion how we come to some decision. Unfortunately, the minister responsible for that act, Minister Favour Williams, is off the island, but I'll brief her and ask her to look at the minutes and the submissions, and hopefully she will be at the next meeting as we make some decisions on the Child Care and Protection Act. We have asked, by the way, we've asked for the data, but all the data we have asked for, they have not been forthcoming as yet, but we expect that we'll get some of these by early next week, all right? Now, in relation to the Child Care and Protection Act, to the best of my understanding, and colleagues, I wouldn't mind your confirmation or, nuance from what I recall of these submissions. Firstly, there was a general feeling that in relation to children, that is 12 to 17, that there should be no minimum mandatory punishment. That's UNICEF in particular took that view, supported by a number of other persons. Others took the view it could be more nuanced and that there should be no minimum mandatory for children between 12 and 15. But for 16 and 17, there could be a minimum mandatory, but it must be less than 20. I mean, figures suggested were 10 and 12, for example. There's also others who took the view that for children between 12 and 15, that if they were going to be sent to prison or some institution, it should not be longer than 7 years, 5 or 7 years. So, members, first we should consider whether we should recommend no minimum mandatory for children generally, first thing. Secondly, if we don't agree with that, whether we should separate them into the categories of 12 to 15 and 16 and 17, and what would be the minimum mandatory for them. And generally, what would be considered appropriate, generally for, dealing with young offenders. So that is in relation to children. We can deal with that. I'll just go ramble a bit if you don't mind. Sure.
Chairman, before you move on, I had asked on the last occasion, and I think you endorsed my request, for the Court Administration Division to provide us with a disaggregation of the data of child offenders between 0 and 17, because we had it as a block at the time. And I think for the consideration that we have to make in relation to your comments now, that data would really be critical to be able to pronounce on the various proposals.
Right, we were promised, we were told it would not be available today,
I see.
but it would be available by Monday the 2nd.
I see. I see.
SG?
Thanks, Chair. I just wanted to understand, I know that you have given directives to the committee, or you're going about it in a certain way, but I just wanted to understand, you said no decisions would be taken. You mean on the matrix, or I wasn't sure, and also you're now discussing some submissions that were put forward and saying this committee would be making recommendations. Recommendations to whom? The reason I'm asking, because...
To the Parliament.
Okay. But normally, a committee has to act within its remit.
Sure.
The remit of this committee, as I understand it, is not in general about children, or not in general about the Child Care and Protection Act.
No, we're talking totally about murders. Murders committed by children,
okay,
or
so that
anyone.
wasn't very clear. I didn't understand that from your comments.
No, I'm sorry.
So when you're talking about mandatory minimum, you really would only be talking about
murders
as it applies to the offense of murder.
Absolutely.
Okay.
That's the only remit we have.
Okay, and then I would then now caution the committee, because whatever decision you take as it relates to murder, you also have to remember that you have mandatory minimum penalties for other offenses. So the decision you would take, if the decision of the committee is to remove mandatory minimum as it relates to child offenders, you would then recognize that it would impact existing mandatory minimum penalties that could also be applied to children for other offenses.
Well, let me...
Which could create an anomaly.
No, let me just say this. Speaking for myself, I'm not speaking for the committee. UNICEF position that we remove it generally is not something that I would adopt, okay? I think there's, at the moment, the Child Care and Protection Act for murder is 10 years. Am I not right? Yes. Is it? Or no, I'm sorry. What is it for at the moment for murder? What is it?
So, Chair, as I understand it, the Child Care Protection Act doesn't actually prescribe a mandatory minimum as it stands now. There's no mandatory minimum prescribed.
Oh, for generally, or just for, not prescribed for murder?
Not prescribed for murder in respect of children.
Okay, all right, I'm sorry.
Could I explain? What Section 78 does is puts a restriction on matters relating to parole. So when they would be eligible for parole, because that is what is actually being amended in this bill.
Okay.
That's before you. And it also speaks about how you deal with children under the age of 14 for offenses specified in the 4th schedule, and the 4th schedule specifies murder as one of those offenses.
Okay.
And it speaks about the fact that you could try to deal with that child who is 14 and under in other ways, but if the court thinks that no other way is suitable to treat the child, then the child could be detained for such period not exceeding 25 years. That is currently in the law now.
Is anyone here from the Ministry of Education? Mr. Bailey, remind me to ask our legal officer from the Ministry of Education to be here for the next sitting, okay? Especially to deal with these matters. Okay, so you can see, members, that there are many permutations that we need to deal with in relation to the Child Care and Protection Act. As I say, at the moment, there's no minimum mandatory. No, go ahead then. So
it's the Offences Against the Person Act that you would look to see what the penalty is for murder. And under the OAPA, it does not distinguish between a child offender or an adult offender.
Okay.
But then what you would then do is go to the Child Care and Protection Act to see what, if any, protections are offered towards children, which is what I spoke of before, about the fact that the child cannot be detained for a period in excess of 25 years if the child is 14 and under, and so on. So Section 78 deals with that. So it doesn't, so the mandatory minimum could apply, because if the mandatory minimum is in the OAPA, it could apply, but then you have to then read it consistent with what's in the OAPA that deals with certain specific provisions as it relates to children.
Right, thanks for that. That is why Senator Campbell has been asking for some information, data.
Yeah. Yes, Chair, and I just wanted to just restate that, SG. So a child offender, 14 and under current law, could very well be subjected to the mandatory minimum penalty that exists in the Offences Against the Person Act, but the court could not institute a sentence exceeding or more than 25 years. So they would serve whatever that mandatory minimum is up to 25 years and no more. Is that, I just want to, for the benefit of my Jamaican family who wading through the various acts that we have to read consistently with. Yep.
So that's my interpretation of the law, except you wouldn't have had an issue with the penalties that now exist. But the issue now arises because the proposal is to increase those existing penalties. And so because of that, you then have the proposal to amend the Child Care and Protection Act in the way it's proposed to ensure that children are dealt with in a special way.
Members, is that clear? So I don't know if anyone would like to come in on the Child Care and Protection Act, because that is a matter which we will discuss and come to some decision when the Minister of Education is here. As I say, more than half the submissions were concern the children, okay? So just to state it very clearly again, the present law, as I understand it, SG, is that a child, be it from 12 to 17, could be sentenced like an adult for a murder offense. Save and except it is subject to the Child Care and Protection Act that the sentence cannot be more than 25 years. Correct?
Well, to use the language, the child cannot be detained for a longer period.
Well, it means the same.
So it's just that, remember that you also have the Parole Act that takes effect. So I'm not sure, I prefer to use the language in the law, because sentence can be, you know, a certain amount, but you also take into account parole. But the point is, no matter what, the child cannot be detained beyond a certain period. And then, if you look back at the amendment that's being proposed, we're not amending 78.4. Sorry, not 78.5, which deals with which talks about the child not being detained for a period exceeding 25 years. We're actually amending a different provision. So that provision remains. The provision that says a child cannot be detained for a longer period, a period exceeding 25 years, remains.
Well,
the proposal isn't to change that provision. It's a different provision that's being changed.
Members, what was proposed by the Ministry of Education, their bill, is that Section 78 should be modified by deleting subsection 3 and then resubstituting subsection 3, which would make it 20 years as the minimum time to be served. Yes, Yes, Mr. Bailey.
Yes, Chairman, I was just confirming what you were saying,
Right.
that the intent was to amend subsection 3 of 78, because subsection 3 as it stands now allows the judge to determine how many years must be served before parole can be considered. And because there's wide latitude given to the judge, we thought it was necessary to put some restriction in place, that a certain number of years had to be served before parole could be considered.
And the maximum penalty under the Child Care and Protection Act is 25. Detention period, same thing. Members, we need to look at these, especially in light of the submissions that came from the various contributors, because as you recall, members, it ranged from no minimum mandatory to nuanced position that we could separate the age. You will recall UNICEF made a very strong plea that we should leave it to the judge. We shouldn't have a minimum mandatory. To be fair, a number of other contributors, in particular Jamaicans for Justice, agreed. But in the case we didn't accept UNICEF position, they would separate the juvenile offenders from 12 to 15 and 16 to 17. And then 16 to 17, they would, right, the age group 16 and 17, they did not object to a minimum mandatory but not exceeding 10 years. And between 12 and 15, they hope that there should be no minimum mandatory, but if at most 7 years. You recall? I think that was the position. Or left to the judge, yes, sir.
Chairman, I think you are omitting one submission from the Office of the Children's Advocate that I think proposed what I considered, on hearing it at the time, a sort of happy medium, although their preference too would have been, Children's Advocate's preference would have been to not have mandatory minimums in relation to children, but she did give a very well-reasoned submission in relation to the Criminal Justice Administration Act and that Section 42K and the ability of the judge to alter the sentencing if it were manifestly unjust and the various criteria that you would meet under that provision. So I know at the time I felt quite engaged by her submission, but I would say, Chairman, that the position of UNICEF and the position of Jamaicans for Justice, I think those two being the most extensive ones in relation to the question of mandatory minimums in general. It's really difficult to pronounce on either of them without that data, because if the argument is no mandatory minimums, or there's a application of mandatory minimums according to the age of the child offender, then we really need to understand what level of offenses, what level of murders committed by child offenders we're seeing and have been seeing. And I know the data that we got was 2016 to 2022, is my recollection. So I think that will give us a much better understanding of what the problem is that we're trying to fix. And I think it's critical before we pronounce on those submissions.
What I'm going to ask the Secretary to do, Senator Campbell, as soon as she gets that information, which is promised for Monday, she circulates it. So we have that even before the next committee meeting. What I'm going to be asking members to do, not only in relation to this, but to really brief ourselves as much as possible on the matrix, the comparison. So when we come, we can make our submissions. But there's no doubt that we have to bear in mind, in relation to the Child Care and Protection Act, what SG has said. Because if we remove the minimum mandatory, it completely affects what is in the Child Care and Protection Act. It would affect generally. So the question is that if we keep it, to what extent we make a division between the different age group, and what would be the appropriate minimum mandatory for different sections. So these are, I'm seeing those possibilities. I'm not ignoring the 42, Section 42 of the Criminal Justice Amendment Act. Senator Scott Motley.
Thank you, Chair. There was also reference to our international obligations, but we weren't pointed to what those really were, and the different treaties that we are a party to. So I wonder if we could extrapolate that so we can have a sense that, because of course we would not want to offend.
Sure, and to be fair, when you look at the submission of UNICEF and also, they refer to it. I think refer to it,
but it was just a reference to the fact that we would be breaching them.
I don't know, SG. International obligations, we are guided, but we are not bound by them. Isn't that the case?
No, we are a signatory. We ratified the Convention on the Rights of the Child, and in fact, I was involved in the CCPA when it was a bill, and we were trying to ensure that we were compliant with our obligations under the Convention on the Rights of the Child. I will look back at what the convention says and the guidance notes around it, but what I recall, though, is that there are times when you have guidance issued to countries, but those are not obligations that we have to implement. From what I recall, we tried to ensure that as best as possible we were compliant with the Convention on the Rights of the Child, because that was the whole point of promulgating the Child Care and Protection Act. So I will look to see if it is guidance, because I think the way the convention puts certain thoughts forward is that states are usually encouraged to use imprisonment as a custodial sentence as a last resort. But from what I recall, it is not a direct obligation. It's more usually an encouragement. But I can check it. And
right.
I think,
no, my recollection, Mr. Bailey, is it more guidance rather than obligation?
So more guidance. And there would have been a case, I think, earlier this year where a child, well, at the time of the commission of the offense, he would have been a child. And the Privy Council had ruled that the international obligations were not
binding.
We're not binding on the country.
That's
so
what I thought.
Therefore, the law as it stood was still constitutional.
You take them into consideration as guidance.
But the Privy Council had still kind of ruled that Jamaica should be leaning in the direction of compliance with the international obligations, but that we were not necessarily bound by them.
Member Williams.
If it pleases you, Mr. Chairman, I just wanted a little clarification on the point raised by Madam SG.
Madam SG.
SG. Just a clarification on the 25 years restriction. Is it for children generally, or is it for children under 14 years? Could you just clarify that for me, please?
it is for children under 14 years.
So that they cannot be detained or sentenced for a period longer than 25 years.
Right.
Under 14.
Under 14.
Thank you very much.
So the point is, which is why I've been having this little debate, notwithstanding any sentence that is imposed, so even if a judge went above and beyond, notwithstanding any sentence that's imposed, notwithstanding whether or not the child is given parole, the child has to be released from detention at 25 years.
So a follow-up question to that is a child over 14 years. Is it that there is no restriction in relation to offenses in the fourth schedule, which would include murder, correct? There would be no restriction for a child 15 years who have committed murder.
Correct, not as it relates to that. But you see, 78.3, the one that we're amending now,
Yes.
spoke about the fact that, I'll just read it, notwithstanding the provisions of the Parole Act on sentencing any child under subsection 1, which is sentence of death, which would be something that would occur for murder.
Yeah, we know that is precluded. Death
And it said the
sentence for
court
children.
may specify, right, the court could specify any period, and that would have applied to all children, except you then had a special restriction for those 14 and under.
And that's what I'm trying to clarify, because looking at 78, where there's a restriction on death sentence, it does say the judge can impose life imprisonment. However, it goes on to restrict that for persons under 14 years of age in terms of the 25 years principle. So the reason why I asked that question is really just to guide myself in relation to what Mr. Chair has asked us to think about the different ranges in terms of how we recommend to the committee. But thank you very much for that.
If you'll allow me, so the act that was repealed and replaced with this Child Care Protection Act was the Juveniles Act. In the Juveniles Act, you had the tiered approach, where you had ranges, 12 to 14. You had ranges, you had the young juveniles and so on. And in fact, what I recall is the reason all of that was changed was again for compliance with the Convention on the Rights of the Child. Saying all of that to say that the proposals to go back to the tiered approach, you would have to consider that very carefully, because that was something we moved away from. Except to say the Parliament did still treat children under 14 differently, because under the Convention, children under 14 are dealt with differently.
SG, why was the age 14 used? I mean, I would have thought 16 would be, what's the difference between 14 and 15? I mean,
our international obligations say that children who attain the age of criminal responsibility, and you know that age ranges from, depending on the jurisdiction you're in. We have 12, but what they found was from the age of criminal responsibility to age 14, those children are at a stage of development where you would think it is appropriate to treat them differently from a child who is 15 and over.
Using my members, if I might use my recollection of criminal law. Well, first of all, the common law position was from 7 to 14. You could be criminally liable, but the prosecution had to show that the child actually understood what they were doing, what he or she was doing. Yes, there had to be a voir dire to determine whether the child knew right from wrong. England and a number of countries remove the minimum age from 7 to 10, but we remove it to 12, so that the age group 12 to 14, there's a presumption that the child does not know right from wrong. There's a burden on the prosecution to prove that the child actually knows what he or she was doing. So that is why the age 14. But once you reach the age 14, it is generally considered that the child knows what they know right from wrong, right? So that is why, that 14 years was important. But in dealing, SG, with say, a matter as serious as murder, could we consider a consideration, rather than being 12 to 14, 12 to 16, what would that be? 12 to 15, sorry. I mean, 12, 15, 16, 17, which is what I think Jamaicans of Justice and a number of other proposals, that we treat the 16 and 17 differently from 12 to 15. SG?
Sorry, you mean 12 to 14? 12 to 14. Because we have,
Okay.
if you give
No,
them
that's a
an
good point.
opportunity, I can look back to see. I think there's at least another place where we,
You see, members,
where
what we're
we
doing,
look
you know,
at 14-year-olds
we're cutting
differently.
it. You see, when you say 12 to 14, it means really 12 to before you reach the age of 15. Once you reach 15, so the split would be between 12 to 14 and 15 to 17. Anyway, it's a matter for us to look at in terms of what was put by the international community in the 14 years. Okay, Mr. Bailey.
So, Minister, just for the benefit of the committee, I just wanted to know that the case that I referenced earlier with Tafari Morrison, that's a Privy Council decision. It's Tafari
Okay.
Morrison. Yes.
In terms of the guidance from international obligations.
From the Privy Council. So they had essentially said that the decision of the legislature to impose minimum sentences for children for certain crimes involving, well, this is specific to firearms, demonstrate a positive legislative decision not to implement those features of the United Nations Convention on the Right of Child requiring detention of children for the possible shortest time. So another obligation under the UNCR is that there should be differentiated treatment of children from adults in terms of sentencing.
Thanks, Mr. Bailey. Yes, SG.
Okay, I found what I was looking for. So in the Child Care and Protection Act, where it deals with section 20, where it deals with evidence of child of tender years, a child of tender years is the age of 14. So what I'm saying is, if you want to make some change in section 78 and no longer use 14, you have to understand that there is some magic to those 14 and under. And it's in more than one provision, so you'd have to be careful about what sort of modification you're going to make.
Quite. So really and truly, remember, I said the proposal was to split the young offenders 12 to 15, and then 16 and 17. It may well be that the proposal is really 12 to 14, and then 15 to 17. Once you reach 15, up to 17, just before you reach age. So members, these are some of the nuances we need to consider when we make some decision with the help of the Ministry of Education and the guidance of our technical team. The next area is generally adults for the capital and non-capital. The real issue there is what should be the minimum mandatory, okay? There, in those two. Speaking for, I have no doubt, and you know, members, the truth of the matter is, one of the reasons we are bringing this to the Parliament and to the country is because of the real outrageous behavior taking place in our country, where persons, you know, can deliberately take it on themselves to go and shoot up. I see MP Karen Morrison just 2 nights ago. 4 persons were killed, and that is a deliberate act. It's the same that happened in Grandspend on Sunday. Whether it is revenge, retaliation, or just outrage, heartless behavior. There were about 4 or 5 fellows who, with submachine gun, just deliberately fired at a group of fellows, and 3 were killed. Fortunately, they were apprehended within a couple of hours. We hope that others, like the one in Crawl, that those, I heard it was 3 people. And you see, the truth of the matter, if they could be apprehended quickly, then people would feel that justice was done. So the Grandspend situation was really, I commended the police, that they were able to identify the getaway car. They were able to see where they were going, and were able to pick them up really within a matter of hours. So it's just to get them to court so that hopefully justice can be done. And it is that quick apprehension that will send the right signal. It takes too long, you know, for justice to be complied with, and that is the problem in our country. But once they're found, and especially if the evidence is strong to get them convicted, I think the country is calling out, and we can't ignore what the country is calling for, severe penalties. And that is why these bills are before us. Now we understand the submissions of the various contributors, especially from Jamaicans for Justice, where we are looking at rehabilitation and consideration of the overcrowding of the prisons and so on. But in truth, members, those of us who have been reading the papers for the last many years, those of us who have seen the behavior of gunmen in particular, who go out without no consideration for human life, my view is that once they are found and the evidence is compelling and they are convicted, that the state should impose the strongest penalty. Now, everyone knows that people are asking for the death penalty. It is still on the statute books. Personally, I hope we don't go there. But at the end of the day, the alternative to the death penalty must be severe and to send the right signal. I think members should consider for capital murder whether we shouldn't insist that the sentence is either death or life imprisonment. The possibility is without parole. Because for capital murder, it's either death, and it should be death, and life imprisonment without parole. Another possibility is life imprisonment with a very high minimum mandatory. What is being proposed in the bill is 50 years. You see, and to be frank, once it's capital, we have to send that signal very clear that that person has been a menace to society and therefore should be locked away for a very, very long time, even to the extent of life. Now, colleagues, the next area is where I believe, you see, we should have some discussions for non-capital murder. Now, non-capital murder, as you'll appreciate, it goes from, should I say, the really egregious to a lot of the domestic murders. That is not to say domestic murders are not egregious, but sometimes a lot of it results from the emotional charge, and oftentimes when it happens, you see some mitigating factors, or you see that, right, there's always, these are matters which I feel, just speaking, that for non-capital, the less egregious cases, we need to be able to allow the judge some discretion. That would be my position. How low we go, we must consider, fine? We have started out, I think, at 30 years. To be fair, persons have suggested 25. Should we go there? The point we're making, members, for capital murder, we must be as severe as we can. For non-capital murder, I feel we could be less severe and allow the court a wide discretion. No, let me hear from you, Member Morrison.
Minister, what do you mean by allow the court a wide discretion? What is the parameter of that discretion?
We can say for non-capital murder, life imprisonment. We can say that, but must serve at least X number of years before release. Or we can say a fixed term, but must serve
at least.
At least. So what we're saying is that in the Act we're providing for non-capital murder, it's either life imprisonment or a fixed term. If it is life imprisonment, we can say X number of years. We must decide on that X number of years. If a fixed term is given, then we can also say a fixed number of years, Y number of years, before parole is considered.
Right. Probably 20 to 30 years.
It's a matter
20
for
years
us.
minimum.
It's a matter for us.
Okay.
Yeah. There's no doubt the likelihood is that it has to be 20 or more.
Yeah.
Because with the Firearms Act, the minimum is 15. You know, just having a firearm. So the likelihood, there's no doubt we wouldn't
right,
go.
And that's my challenge
Right.
with discretion, because what we don't want is to have an incongruity when we compare with other crimes.
Absolutely.
Yes.
So I have just put that broad parameters without us making a decision now, colleagues, and for us to start thinking about it, looking at what is in the matrix, looking at the submissions, so that at least persons who came here and made contribution, they should at least know that we have taken what they have said. We don't have to accept what they say, but we should at least take into consideration in making our decision. Okay? Any other views that anyone would like to express? Yes, SG.
Thanks, Chair. I'm very grateful to the CPC, as always. I have to make a correction to something I said earlier. I had referred to Section 20 of the Child Care Protection Act. That was repealed in 2016, but there are still other references to children of like 14 years. So for instance, with light work, or those who are completely prohibited from work and those who are allowed to conduct what's called light work, it still talks about a child not attaining the age of 15, which would mean 14, between 13 and 14, you can do light work. And even in Section 79, there is still also a distinction made using the age.
Okay.
So there is really still a theme still in the Child Care Protection Act.
There's, fine, thanks, SG. There's one other matter, members, that I'm asking for your consideration. In respect of murder, non-capital murder in particular, if the person pleads guilty, then we're urging that there can be negotiation between the defense and the prosecution to come to an appropriate sentence. Okay? So if that, we agree to that, I'm wondering if we shouldn't remove from the Criminal Justice Administration Amendment Act, which allows 1/3 and, you know, if you plead guilty at the first opportunity, or don't hold me to it, 1/3 and then 2/5 or whatever the figure is. Because the reason for this, you see, is that I've mentioned it last time, but it seems to me that when, you know, you plead guilty to non-capital murder, for example, I think it would be useful for the family and friends of the victim to be fully consulted before a sentence is imposed. Not that it is, not that, you know, it binds the court. But the truth of the matter is that I've seen far too many cases in Jamaica where after the sentence is imposed, the family go out and quarrel, you know, about the man get off.
And this assumes in my mind that, so you commence a plea bargain, and that is between the defender and the prosecution.
Yes.
But then the family of the victim would be unaware.
No. The Act provides for the prosecution to be in touch with the family.
So there is consultation, because I think there was one group, JFJ, I believe, would have been suggesting that there ought to be some consultation.
No, the Plea Negotiation Act requires that.
But where does the judge come in this in terms of the flexibility to first allow, and then is there I believe JFJ again spoke of some levels of parameters to allow for the negotiation to take place.
No, there's no doubt that the prosecution in particular would be looking at these sentences in negotiating with the defense. But the defense and the prosecution agreeing is not the end of the matter. The judge is the final arbiter. So as I mentioned last time, if the judge does not agree, then the matter ends there, the matter goes to another court. You're with me? In other words, it has to be tried. If let us assume the...
Let me clarify something in my mind when you say, if the judge does not agree. Because the approach and the opportunity is there for the plea bargaining to take place.
Quite.
So are you saying that upon the request, the judge may not agree? Yes. And there would have been circumstances to dictate that?
Well, you know, the court, obviously, I would expect that in 99.9% of the cases, that the defense and the prosecution, and I've been a part to many of these, we go in and we get some indication from the judge of what would be appropriate.
Okay.
Right?
Okay.
But the act itself says that if the defense and the prosecution agree on a sentence, and the judge say no, if they can't change it, because, to give you an example, Senator Gill, the defense may say, I will only cause my client to plead guilty if the sentence is 20 years.
Right.
Prosecution will say, okay, but the judge might say, no, this is 30 years. So the defense might withdraw and the matter start afresh.
And here
let me just finish this one. The defense and the prosecution might agree on 10 years. And the judge said, no way, not in this court, nothing less than 25 years. You're with me, so the defense would withdraw.
And that's why, in my mind, in the first instance, I would have thought that there should have been a minimum or maximum parameter allowed for negotiations to take place, whether it's between 20 years to 35 years, for argument's sake.
To be fair,
yes,
there's no doubt that both defense and the prosecution would have to get that parameter with the judge.
With the judge.
And I can tell you, that is the norm. I think defense counsel who are here will tell you that happens. Whenever accused want to plead guilty, they get an idea. They get an idea from the judge.
They get a vibe.
Before they go and persuade the accused to plead guilty. I mean, I know this, you know, in my years of practice.
You see, this is a particular area that we'd be looking at, and you want to ensure that whatever you are promoting, it facilitates that the activity works.
Sure.
Yeah? And that there's full awareness of it.
Absolutely.
Yeah?
So to be fair, Senator Gill, with the minimum mandatory that we are proposing, that is going to be the guidance that will be given to defense, prosecution, and judge. Can you imagine if we put a minimum mandatory of 25 years, the judge give 5 years? there would be so much outcry. But I can see the possibility of a 20 years. Mm-hmm. You understand? Because of the plea guilty, they might take off for 5 years. So that is how it works, to the best of my knowledge, when defense and prosecution, because usually when you go in, Senator again, the judge will say, well, you know, a matter like this is usually 10 years. And you will say to the judge, well, could you take off 4 years? And the judge says, no, can't take off more than 2 years, something like that. I think I'm right.
So what you would have done, Chair, by way of us deliberating this afternoon, is to categorize, in my mind, at least 4 areas for the committee to consider. From capital murders to non-capital, to the plea bargain, that is what, 3, and to how we treat with the child offenders.
Right.
Right, so we would have categorized and condense our discussion into those pillars.
There might be others, but for
and
the
there
moment,
might be
the answer
others,
is yes.
but the major pillars. And I believe the easiest one is what would have triggered us to come here, capital murders.
Absolutely. All right. As I said, I had hope that this would be a short session. So if there are no other matters and under consideration, we are going to ask, I'm proposing some dates. Sorry.
Well, Chair, that's exactly where I was going, because I just wanted to make a special request that we have sufficient time between this meeting and the next. It's quite a bit of documents that we need to go through, and I would hate for us to have too short a time to be able to.
I can tell you, we were thinking of at least 3 weeks.
Yes.
So,
yes, thank you.
So we are looking, what was it? What was the date I said 3 weeks? All right, we're thinking of the 18th. The 18th, that's the 18th on Wednesday at 2 o'clock. And we also booked the 18th and the 25th. The 18th and the 25th at 2 o'clock. Oh, no, the 25th will be at 10, but the 18th will be at 2. So it gives us a good amount of time. And I'll ask the Secretary to send the information and to remind us that on the 18th, we just confirm all the minutes, look at the matrix. 10. No, the 18th is at 2 and the 25th at 10. Sorry about that. I want to thank the technical team. And the technical team, please, you heard some of the discussion. And if you don't mind, we want you to guide us. And if there are any concerns that you have from the discussion, as CPC quickly was able to correct a matter, any concerns, please don't be afraid to guide us, okay? So members, I want to thank you for the afternoon session here and thank the technical team from the ministries. And if there are no further matters, can I ask a motion for adjournment? Thank you. Meeting adjourned.
The Joint Select Committee of Parliament considering job descriptions, codes of conduct and performance standards for parliamentarians wants to hear from you. Send your opinions in writing by Tuesday, October 3, 2023 to Clerk to the Houses, Gordon House, 81 Duke Street, Kingston. Or email us at clark@japarliament.gov.jm. Visit the Parliament's website at www.japarliament.gov.jm for details.
In STEM, the teaching is learn by doing. So students don't learn by you telling them what